Number 66, People v. George Garcia.
May it please the court. Matthew Bova from Mr. Garcia. I would request 3 minutes for rebuttal, please.
Yes.
The Supreme Court has already decided the standing issue that is currently being litigated before this court. Staub, Shuttlesworth, and Smith all confirm with not ambiguous language, crystal clear language. And just to quote it, because I think it's important for the words to get their day, because this issue is being litigated as if we're operating on sort of a blank canvas, but we're certainly not. The Supreme Court has, quote, uniformly held that the failure to apply for a license under an ordinance which, on its face, violates the Constitution does not preclude review in this court of a judgment of conviction under such an ordinance. The Constitution can hardly be thought to deny to one subjected to the restraints of such an ordinance the right to attack its constitutionality because he has not yielded it to its demands. That's the Supreme Court in Staub. That rule was affirmed in Smith and Shuttlesworth. The government's argument now is, well, at first the government's argument was that's limited to the First Amendment, but Smith was a Supreme Court case that enforced this rule that you do not have to submit and try to comply with an unconstitutional licensing scheme in order to later challenge it. Smith enforced that rule, and Smith was not a First Amendment case. It was a substantive due process case. It was basically
Let's assume we agree. So how do we get our facial challenge to give life to those words that you just said?
Right, so what Shuttlesworth, Smith, and Staub confirm is that when you're attacking the standard itself, you do not have to try to circumvent and surmount that standard in order to later have standing. If the standard itself is facially valid and you simply want to argue that as it was applied in your case, for example, that the licensing official just went off the rails and improperly denied your application because of your unique facts, that has to be litigated. That has to be, as the Chief Judge was explaining in terms of a way of thinking about that, exhausted. The same thing is true when it comes to when it comes to an order that a court issues. In order to, you cannot just violate a judicial order or an injunction. You have to challenge that in court. But Shuttlesworth, Smith, and Staub confirm that when it is an unconstitutional statute or ordinance, you do not have to do
We can do the facial challenge right here, right now? This case is bringing that facial challenge to us? Is that what you're saying?
Yes, so the facial challenge here is to the proper cause requirement. So the proper cause requirement has been facially invalidated. The remaining question then is a question basically of traceability and remedy.
What about, you were speaking about the statute. Are you saying that the entire New York statute is thrown out the window and New York can no longer license people, so preservation is not required?
No, not at all. No, licensing is permissible. The problem is licensing is unconstitutional when you have an unconstitutional licensing standard. I mean, the arguments really just beg the question. Of course licensing
Which parts are unconstitutional?
So the proper cause standard is unconstitutional. So
But I understood your quotes to those prior cases to speak about submitting yourself to an unconstitutional regime, not to a regime that has one unconstitutional element. Am I misunderstanding your quote or what this case is holding?
No, the number of, the question of whether there's one unconstitutional standard or whether 1 of 5 is unconstitutional, whether 10 out of 10 is unconstitutional, that doesn't matter. The bottom line is when the statute or ordinance has an unconstitutional standard, proper cause standard, which Bruin held was unconstitutional, my client, Mr. Garcia, and anyone else did not have to try to satisfy that first, lose, and then
But doesn't that fly in the face of the Kavanaugh and the Alito concurrences where they sort of go out of their way to say, we're not saying there's no such thing as a constitutional licensing regime. They exist. So I think the elements versus totality distinction is important.
No, but what those opinions are holding, and the same thing with the majority opinion in Bruin, is that you can have some constitutional licensing requirements. You can have age restrictions.
To that end, you mentioned traceability.
Yes,
You
sure.
said we come to traceability. So how can we ascertain whether or not any alleged injury your client might have suffered from being subjected to a licensing regime that included proper cause is traceable to the proper cause requirement if there has not been a litigation in the first instance that figures out whether there might be other disqualifying factors that would have kept your client or any other defendant from getting a license? I'm not sure how we could know it's traceable there.
Well, the government hasn't identified hasn't even tried to speculate as to any possible barriers, the alternative to proper cause. But the answer there is a remand. I mean, I think really what we're talking about here are two choices. Do we engage in the limited remedy of remand, or do we forever choke off appellate review of a fundamental constitutional claim? And I think that the Constitution...
Go ahead.
I think that the Constitution says when you have those two options, we should favor the constitutional right, and if all we're asking for is a narrow remand to develop the record on that issue, that should be the remedy. Particularly where, for example, in Mr. Garcia's case, he had a Utah license. The government is purely speculating that there may be some possible provisions. There's no...
What would the narrow issue be for which you would seek a remand?
So the questions that would be developed on remand would be, one, are there any provisions that would have applied to Mr. Garcia so as to bar him from a license? And assuming there are any of those provisions also constitutional? I mean, for example, the good moral character provision is another alternative provision in the statute that is likely more unconstitutional than proper cause. I don't think it's hard to imagine a standard more subjective than having one's rights hinge on a local government agent's assessment of one's good moral character. And the government has not even tried in the 6 cases before this court where that issue is all in play to even suggest that there's a historical tradition justifying such an arbitrary standard. So that's all that is the way to handle that, is it gets remanded for a hearing on those issues, and the question of whether there are alternative justifications for denying the license can be hashed out. And I think that also gets...
So are you saying that determinations in all cases where a person such as your client has a license elsewhere, it is okay for them to come in, not apply, and go through a criminal proceeding and then decide that it's unconstitutional because there was no showing by the people that they would have otherwise been disqualified?
No, so the Supreme Court has said that the question of whether you do the upfront application, whether you try to surmount the unconstitutional standard, you don't have to do that first in order to later have a defense.
No, what I'm saying to you is that what you are clearly saying is New York can't require people to apply.
Where New York has an unconstitutional licensing scheme, yes. That is the rule from Staub, Smith, and Shuttlesworth.
I understand, but you're saying the proper cause part was what the Supreme Court struck down, correct?
Yes, Your Honor.
So now there's a blanket prohibition with respect to other parts of the statute?
No, it's simply that the government is suggesting that what Mr. Garcia had to do...
It's their burden to show that he would not otherwise qualify.
Yes, and what the government is suggesting is that Mr. Garcia had to look at an unconstitutional licensing provision in the face and say, I have to now try to somehow persuade the local official that I can satisfy the unconstitutional standard, get it denied, and only then do I have a defense. And that is exactly what Staub, Smith, and Shuttlesworth reject.
But isn't the argument really that what he had an obligation to do is show that that's what they relied on in denying him a license? Right? I mean, if you apply and they say you haven't shown this extra thing, which is now everyone agrees is unconstitutional, okay, then you have that. But there might have been another reason, and now what you're asking is for this court to send it back for a proceeding like that to take place in this criminal proceeding, right? Like, why didn't he have an obligation to apply for a license and get a determination that it was that particular provision that kept him from getting a carry permit?
Well, because you could say the same thing about any unconstitutional scheme. Almost every licensing scheme has many provisions. But the Supreme Court has never said, well, every single one has to be found unconstitutional in order for you not to have to first apply.
Let's say there's one of your examples, let's say there's you have to get a license to have to speak. It's a First Amendment issue. And there are 10 things in that statute that can prevent you from getting a license. And one of them is, the podium you want to speak of is a certain level. And for some reason, that's tossed. Okay, that's unconstitutional. Now everyone can just say, well, I didn't need a permit because, look at that podium provision in there. And there might be 9 reasons that person under the statute wouldn't have gotten a permit.
No, so the question of standing is resolved by looking at the statute and saying, does it have an unconstitutional provision? Then we look to Staub and Shuttlesworth, which hold that you don't have to apply. The question, though...
Shuttlesworth and Staub, was there any indication, and I don't recall, that the individuals would clearly have been ineligible for a license for some reason other than the ground that they were saying was impermissible?
No. In those...
So that's different here, though, right? I mean, here because they didn't apply and there are a number of different grounds, we don't know whether they might have been ineligible for a license in any event.
But I think, though, what's happening is the two doctrines are being merged together.
Which two?
So the standing rule, which governs whether you have to make an application,
Yes.
and the question of traceability. What the Supreme Court is basically saying in Staub, Shuttlesworth, and Smith is that when a statute is unconstitutional, it's void. A person does not have to try to satisfy it first.
So
but the question of...
What's the genesis of the traceability requirement if it's not part of standing?
No, it is, but all I'm saying is that traceability comes in when we're looking at whether or not the unconstitutional standard has harmed the individual who's litigating the claim. And so for Mr. Garcia, for example, if there were some other standard in the licensing scene that could have barred him, then he didn't have to make the application first. He didn't have to first try to surmount the proper cause standard, but he would not be able to show traceability when litigating the claim as a defense.
New York's attorney licensing regime also has a good moral character element to it. So in this, based on your argument, a defendant who's looking at a charge of practicing law without a license doesn't really have to challenge that element until they're convicted, or doesn't have to apply for a license, and may permissibly challenge that element after conviction, saying it was an unconstitutional requirement.
Right, so yes, I mean, if I understand the hypothetical correctly, I think that's...
I'm not sure I understand the hypothetical correctly.
Well, maybe I could try to just recreate it a little bit. So if there's a statute that says that the unlicensed practice of law is a felony, it's not, but let's assume there is one. And it also says that in order to get a license to practice law, you need to show 2 things. One is you have to be a really, really good writer, and 2 is the local court system has to deem you so worthy of a license that we can confirm that justice will absolutely be served.
No, just they have to deem you a person of good moral character. We have character and fitness requirements.
Well, but that, in the lawyer context, that's a constitutional standard. So I'm just trying to create a hypothetical with clearly unconstitutional standards. The fact that there's one is unconstitutional, 2 is unconstitutional, 4 is unconstitutional, it really doesn't matter. The bottom line is that attorney can hold him or herself out as a lawyer because there was an unconstitutional standard in play, and then be able to raise that as a defense. If there was another standard that clearly barred that license, then the claim fails for lack of harm, for lack of traceability.
Why isn't it really that it really is a facial standard at the end of the day? Because don't you have to show that every single requirement is unconstitutional?
No, because some are also factually inapplicable.
And
So-
then it's as applied,
No, so
if it's unique to the individual's facts.
when assessing the remedy and traceability, yes, you do then have to look at each individual. There may be some people who couldn't satisfy the proper cause, who are subject to the proper cause standard, but they're also 16 years old. In a case like that, under Smith, Staub, and Shuttlesworth, you didn't have to make the application to have standing later to challenge the proper cause, but you can't show traceability because the age restriction would have prevented you anyway. So I think it's just important when we're thinking about this just to divvy it up between The question of the threshold requirement that you make the application, and then the additional analysis once we're in court about traceability. And I just want to also say, too, that Mr. Garcia was also convicted of intent to use unlawfully, not just simple possession, which is a unique issue in this case compared to the rest of the cases. And there is no historical tradition that the government has been able to meet its burden of identifying.
How would the traceability work in a criminal case? So the government now, it seems to be, you're saying, has the burden of showing you wouldn't have gotten a license under one of the other provisions? Is that what would happen here?
Yes, I mean, I think that sounds...
What if the
that's
defendant
right.
says, no, I'm not going to cooperate in that kind of inquiry, I would incriminate myself? You go ahead, try.
Well, I mean,
What
I
do
think
they
the
do?
question of burden at the remand hearing as to whether there's alternative basis for denying the license, I think that if it's, I mean, I think I could imagine a situation where the burden would rest on the defendant to show that there are no other grounds for denying the license as well. I mean, I
Would
think-
this be one of those situations? If it goes back, would the burden be on the defendant to show that the other provisions don't bar him from getting a
I
license?
mean, I think in a case like this, we would not have a problem with that. I think that also is consistent with the general rule that the challenger has the burden of proving both the unconstitutionality and also injury in fact and traceability. And I'd also, I mean, I can comfortably give that answer too, because I think this record overwhelmingly shows that there's no other constitutional justification for denying Mr. Garcia a license. I see my time
Sorry,
has
but that's, perhaps I'm just misunderstanding this, I'm dense, it's late, I don't know. But it sounds to me like this last point you made is the facial challenge, that every other provision renders this unconstitutional with respect to your client. Or did I misunderstand what you just said?
So, just as a, there are other provisions in the licensing scheme other than proper cause.
Yes.
And the question for the remand is going to be whether A, those provisions are constitutional, and B, if they are they actually applicable to Mr. Garcia?
Okay, but on A, that strikes me as a facial challenge.
Well, there may be facial challenge.
I thought the argument was under Bruin, all of those requirements fail.
No, not all of them.
Okay.
Not all of them. I mean, I think it's very
What's
clear.
the constitutional argument on the one that doesn't fit the not all of them?
So, I think the age restriction, for example, the predicate.
That doesn't apply to him at all anyway.
Right. So and it's an open question too about whether restrictions like substance abuse. I mean, our position is that the mere prior act of engaging in the use of a controlled substance does not disarm you. But I think all those questions just get hashed out at remand, and questions also as to good moral character. That too is patently
As
unconstitutional.
opposed to you saying this would be the only ground upon which, given all those requirements, is the only ground upon which the defendant could have been denied a license, and here's our arguments why they should not have been denied a license on that ground.
No, ultimately, the position that we would be raising at the hearing would be that the only justification
Yes,
that in the licensing statute
Yes.
that could apply to Mr. Garcia would have been the proper cause. Everything else was either inapplicable or unconstitutional. That would be ultimately the position we'd have to prevail on at a remand.
Should the judge then essentially engage in a licensing decision? Like you would have to provide the information to the judge that you would have provided to New York State to get a license, and the judge makes a determination of whether or not I would issue you a license on these. Are you of good moral character? Are you this? Are you that? Do you fit in these exceptions? Is that what we're asking the trial judge to do here?
I mean, I don't think necessarily, because if you have a subjective standard that is constitutional, then I think that would defeat the claim. I mean, if the good moral character standard is constitutional, I think that does in many ways sever the traceability point, because we never tried to satisfy that either.
And on the remittal, the burden that you are willing to assume, or your client's willing to assume, is production or is it proof, and if so, under what standard?
Well, generally, the standard for raising a constitutional challenge is preponderance of the evidence. So I think that's also generally the standard that would govern standing inquiries. So I think that the standard would be that Mr. Garcia would have to show that any other alternative theory is either factually inapplicable or unconstitutional under
It would be
Bruin.
his burden to prove that under a preponderance standard.
Yes, yes, because that's just generally consistent with the rules that govern constitutional challenges. Thank you.
Thank you.
May it please the court, Stephen Wu for the people. On standing, the First Amendment cases that defendant relies upon here are categorically inapplicable. They rely upon a finding that the underlying licensing scheme is on its face violates the Constitution, and that is simply not something the Supreme Court found in Bruin here. What defendant conflates is a decision that found a specific requirement that indisputably applied to the plaintiffs there, unconstitutional, with something that invalidated the licensing scheme as a whole. And Bruin simply didn't do that. The majority and the concurring opinions went out of their way to emphasize that licensing could continue to be imposed, and therefore states could also impose penalties for failing to comply with the licensing requirement. And the problem with...
Let me just stop you there for a second. So suppose instead of a proper cause requirement, New York had a statute that said African Americans can't apply for licenses. Is that facially unconstitutional or no?
That requirement might be unconstitutional and should be...
Is the statute then facially unconstitutional?
If the underlying licensing scheme is not declared separately unconstitutional, it is not
I'm not asking about
unconstitutional to
declaration.
apply for the license.
So I'm asking you the following.
Understood.
Assume that instead of proper cause, it says African Americans cannot obtain firearm licenses. And actually, New York had a statute like that a long time ago. Assume that's the statute. Is that statute facially unconstitutional?
The requirement to satisfy that provision that you identified would be unconstitutional, but the need to submit to the licensing scheme at all would not be. And again, this is not a point to infer from Bruin. Bruin said two things in its holdings. It said, one, the proper cause requirement could not be enforced. And it said that holding does not mean that states cannot apply licensing requirements. So the Supreme Court answered what would be necessary in the First Amendment context to find the licensing scheme unconstitutional on its face. It said licensing is permissible here. And the problem with defendants' failure to apply...
I'll try one more time and then I'll give up. Is your answer that my hypothetical statute is not facially unconstitutional?
The requirement
No,
that
the
you
statute.
identified... No, but this is the answer to your question.
Okay.
The specific requirement that is imposed would be unconstitutional, and whether it's requiring someone to not be African American or requiring someone to establish proper cause. But that doesn't necessarily mean that the need to have a license would be facially unconstitutional.
Doesn't it turn on whether that provision is severable?
It does, and in this case, we know it is severable because the legislature literally severed the proper cause requirement in response to Bruin here. And I do think that is the way to sort of like square this circle here.
So let's try these questions this last way, perhaps this last way. Maybe I should not have said that. The provision as described by the Chief Judge is found unconstitutional. The day after that decision, can an African American go seek a license, and would they then have to satisfy the other requirements of the statute?
Yes, they would. They absolutely would have to satisfy the other requirements of the statute, and the state would be entitled to say that someone
As
who
would
didn't...
anyone else.
As would anybody else, and the state would be entitled to say that somebody who didn't even try to apply for a license and didn't get one can be criminally penalized here. And I don't want to spend too much time on standing. The one other thing I do want to say about it is that the reason that standing matters here is in part because of the specific nature of the challenge the defendant is making. What defendant has made clear is that the source of the constitutional problem here is being subjected to the proper cause requirement. That's the predicate for their constitutional claim. But as Judge Halligan said, there's a traceability issue here. We don't know that defendant would have been subjected to the proper cause requirement. We don't know that he would have been denied a license at all if he had actually applied. This is a defendant, unlike others today, who had no criminal history, is certainly not under 18, lives in New York, right, has no evident history of drug use. And when he testified at trial about why he didn't apply for a license, it wasn't because he couldn't establish proper cause or whatever. What he said was he didn't want to undergo the burden and expense of applying for a license in New York. That was his reason given for it. So there's no showing that he would have been denied a license at all, let alone for proper cause. And so he can't show that the source of his constitutional problem, which is the proper cause requirement, would have even affected him. That is why he lacks a standing to raise the specific argument that he is making here.
Can I ask you about that? So what I'm grappling with is he was convicted under a statute which he argues is unconstitutional because it rests on a licensing regime which itself had a component which the Supreme Court said was unconstitutional, right? And so it seems to me there is a common sense way in which he was aggrieved by that conviction in a way that generally, rests on injury in fact and traceability and redressability. So why is the traceability analysis more complicated in the way you're identifying?
Well, so I would distinguish two ways of understanding standing here. There's no dispute that he has standing to raise a challenge to his criminal conviction because he was in fact convicted. That's not what the people's argument is. But the way that defendant has chosen to bring a specific argument to challenge his conviction is to say that he was improperly subjected to the proper cause requirement. That is the collateral challenge he's raising. That is the predicate for his challenge to his conviction. And in order to raise that specific argument, he needs to establish that the proper cause requirement would have applied to him, and he hasn't satisfied that. So as the Attorney General said in the previous argument, standing is in a way a misnomer. It's not about standing to challenge his conviction. It's about standing, whether it's prudential Article III version, to raise a specific argument that he now relies upon, which would be the same type of argument that the Bruin plaintiffs raised in their civil challenge.
Is what precisely?
It is the version of the argument they have made here, which is that because the proper cause requirement is unconstitutional and applied to me, right, which is the missing predicate, applied to me, I cannot be convicted. And again, because that is the version of the argument that he has chosen to raise, he is held to that burden. And I should say, De Castro makes that clear. It's the Second Circuit case, not one from this court. But in De Castro looked at two different arguments. One was an argument based upon a predicate challenge to the licensing scheme, and it said there was no standing in this sense of the word to raise that argument. And then it did go on to consider a challenge to the federal conviction under 922 based on other grounds. So it wasn't that the defendant couldn't raise any challenge whatsoever, just the licensing-based one, which is similar to the argument the defendant is raising here. And one very last point on standing, remand is not a substitute here for what the right question would be, and would not be a solution here in any event. The question in this case is what administrative officials, considering a license application from someone who actually wants to get it, would have said if he had applied. But a remand here would not involve the licensing officials. The district attorney's office does not grant gun licenses. It's the NYPD in New York City. And defendants and the prosecutor's burdens here would be topsy-turvy. Defendant would be here arguing, I would never have gotten this license. And I guess the prosecutor would be arguing that he could have gotten this license. And so the incentives would be entirely skewed. And I think what this means is that the remand doesn't actually answer the question that is relevant for the standing question, which is what would a licensing official have done if defendant had actually tried to get a license here, and neither of those would be present.
Am I right that in some places, not in New York City, but some other places in New York State, a court is the licensing authority?
That is correct, upstate outside of New York City. And so, in a remand in those situations would not bring in the types of courts that would issue the licenses, is my understanding. It would go back to the local criminal court, not to the licensing officials either.
So if a defendant in a subsequent case is convicted of CPW and has the view that one of the other components of the licensing regime is unconstitutional, and your adversary identified a few he thought might fall in that category, is that defendant unable, because he or she lacks standing, to challenge the conviction if he or she hasn't applied for a license?
Well, Bach versus Pataki did recognize a futility exception in this respect, which is if it would be futile to have applied at all, and it was clear from the record that that was true, you might be able to get around it.
For example, I understand that the prior felony has been litigated in the Third Circuit, but if there was that sort of restriction and you were ineligible for a specific reason, you would say that there was standing there, but not if you weren't necessarily otherwise disqualified?
Right. There might be, under Second Circuit precedent, a futility exception to applying for a license in those circumstances. And the distinction in this case is that, as I said, it is not clear he would have been denied a license, nor is it clear the specific grounds on which he would have been denied a license, unlike in a case like Bach versus Pataki, where there was no real dispute that he would have been denied on residency grounds. I do want to address the merits of the Bruin claims before I sit down here, because this case does raise two distinct issues on Bruin that the other cases don't. And one is on the possession with intent to use unlawfully conviction. Bruin itself rebuts the defendant's argument that there is any constitutional entitlement to possess with the intent to use a firearm unlawfully against another person. The Second Amendment right defined in Bruin was limited to law-abiding citizens who use firearms for self-defense. And somebody's intent to use something unlawfully against another is categorically inconsistent with that type of a protection here. And Bruin also went through historical evidence that showed multiple examples of situations where there were regulations of what it called well-defined restrictions governing the intent for which one could carry arms. And this case shows a perfect example of the type of conduct for which regulations were historically permissible. This defendant, without any provocation, went to his car, got his firearm out there, and was returning to a club to shoot somebody or threaten them. He was under no threat. He was being followed by nobody. He was engaged in what Bruin would call an intent to create fear and terror in others, and that has been constitutionally permissible as a source of regulation for hundreds of years.
But isn't the issue, counsel, really, can you have a presumption that that was the intent from conduct protected by the Second Amendment?
And that is the second distinct issue, is the operation of the presumption here. As a threshold matter, I will raise just one preservation argument on presumption, which is this was obviously not raised below. And preservation here is something that would have been valuable. The court and the parties here spent a considerable amount of time thinking about how to instruct the jury on this exact question, is what inferences to draw from possession. And there's no indication that this very conscientious court wouldn't have entertained or thought about ways of changing the instructions to the jury in response to a constitutional concern. So this is a situation where preservation would have been very valuable, and there is nothing that defendant has identified that would have obviously foreclosed a constitutional argument here. When this court considered the presumption in Galindo, it made a point of saying that there was no constitutional objection to the presumption there. Defendant could have raised one here. They've cited no Court of Appeals, Appellate Division, Supreme Court precedent that would have foreclosed such a challenge. So we do think this could be resolved just on preservation alone. On the merits of the presumption, the right test to apply is the one from Ulster County here. And that is because the defendant here is raising a challenge to what he deems to be the rationality of the presumption, drawing from the basic fact of possession to the elemental fact of unlawful intent. And what Ulster County made clear is that in interpreting that rationality in a case where there's a permissive presumption, you start with the facts of the case. And the facts of the case, as I said, have direct evidence of defendant's intent to use the firearm unlawfully.
And if there were no facts, would the presumption alone then be unconstitutional?
Well, I would say this,
if relied on that presumption?
if there were no facts, then the bare rationality of the presumption alone would actually be presented and is not presented here. In the abstract, our position is that the presumption is in fact rational here. And I think the error with defendant's argument is the assumption that the presumption is from otherwise lawful possession of a firearm, and it is not. The presumption here comes, one, from someone's unlicensed possession of a firearm, meaning that the individual has necessarily already violated the law. It is a violation of a law that is intended to determine if somebody has lawful uses for the firearm and can responsibly use it. And so there's a nexus between what the licensing scheme does and the question of lawful intent. And in this case, and in other cases as well, there's a standard instruction that if the defendant is justified, there is no lawful intent. And so this is a case where the possession is from someone who has violated the law, has no justified self-defense need for the firearm, and it is from those facts that the presumption is drawn that there's unlawful intent. And that is a rational presumption that is a permissive one, and the jury is entitled to accept
In
or
a way,
reject.
I see this argument, but I see it in some way based on a different problem, which is to convict of the underlying crime, you need to show the person's unlicensed, and under the New York approach to that, that was the defendant's at least burden of production, right? So if that falls, then your unlicensed public carry falls, right?
Well, that exact question is not presented in our case, and part of it is because there was no real dispute here, including from defendant's own testimony, that he lacked a license. So whoever bore the burden here, it was clear at the trial the defendant lacked a New York license, knew he lacked a New York license, and knew that he had to get licensed here. So this is not a case where I think that problem raises for us. But I do want to make a point of saying that this is a case where the bare presumption from possession alone or from unlicensed possession truly was not in effect. The prosecutor made no mention of the presumption during summation, instead spent considerable time outlining the evidence of unlawful intent. So if there is a case where the concern is whether the presumption alone might operate in a way to undermine the defendant's rights, this is certainly not the case to consider that question.
Thank you.
Thank you.
May it please the court, Andrew Amond for the Attorney General. Following his arrest for unlawful gun possession after an altercation with another patron at a nearby nightclub, defendant George Garcia said the other patron was lucky the arrest occurred because of what defendant planned to do once he got back to the nightclub. The jury rejected the invitation to find that any threat to defendant or the girlfriend provided justification, negating the defendant's intent to use the pistol unlawfully against another. At no point in the trial court did defendant argue that his prosecution violated a Second Amendment right to carry a handgun for self-defense, and the Second Amendment challenges he belatedly attempts to raise now are unpreserved, barred by lack of standing, and meritless. I'd like to say a couple of things about preservation that might, I hope, will be considered helpful by the court as highlights in addition to what very capable counsel have already said. If it were true that there were simply an exception for U.S. Supreme Court precedent that changed the law in New York, we would expect to see a lot more examples of it. And what we actually have is the opposite. People versus Walker, that's in 1988, 71 New York 2nd, 1018. This court applied preservation to bar a claim under Cruz versus New York that was decided after the defendant's trial in that case. People versus Gonzalez, 55 New York 2nd, 887, 1982. A more recent example, People versus Douglas, 4 New York 3rd, 777, 2005. That was a claim under Crawford, which did apply a new framework to a constitutional right, the right to confrontation. This court reached a confrontation clause issue, but only after noting that the issue had specifically been preserved by the objection at trial. If there were this exception as broad as defendant argues, an awful lot of cases from this court would have had to turn out differently. On standing, I would say that the cases that the defendant cites, including Smith, including Staub, including Shuttlesworth, none of them involved the paradigm we have here, where there is a single readily excisable criterion from a licensing statute that is held to be unconstitutional. There was something that made the scheme void in toto because the conduct itself couldn't be subject to licensing, or the licensing regime functioned systematically with such vast discretion that it was void in all its applications. When there is, however, a readily, excisable provision from a criminal statute, or in this case, it's not even a criminal statute, it was in the licensing regime, the answer is not to say that everyone who violated the statute before gets to go free. It is instead to just excise that provision. And I would cite to this court People versus Liberta, that's 64 New York 2nd, 152 in 1984, where this court held that the exception to the rape statute for married spouses was unconstitutional. Obviously, the holding was simply that that exception was stricken from the statute, not that everyone who had violated the statute previously and been convicted under it got a free pass because there was one unconstitutional piece in the statute. I'd also like to point out something about standing that counsel haven't really discussed here. This is an individual who could have gotten a premises or restricted carry license by his own claims, which would have been a complete defense to the charges that he now faces, including for possessing a pistol with intent to use it unlawfully. He wouldn't have had to show proper cause, which he claims would be the only impediment. And in fact, there was evidence that he used his gun, other than on this occasion, just to go to shooting ranges.
Slow that down on that for a second. So if he had applied for a, let's say, home license only, right, he could have gotten that without a proper cause showing.
Yes,
And I think you said that would have provided him a defense against these charges,
correct.
including the intent to use unlawfully?
That is correct.
Really?
Yes.
Okay. Can you explain that?
Yes, this court read the language that now appears this is 400.0017 of the penal law, that says that having a license issued under section 400.00, having that license is an exemption from prosecution under Article 265 of the penal law. And it's cited in our brief. I'm sorry, I don't remember
That's
the
People v.
exact site.
Parker.
But
That's People v. Parker, yes?
The facts of that case, if I'm recalling it correctly, is that someone had a firearm license for a gun in their home. They were outside of their home on the street, like threatening to shoot their girlfriend, or I believe it started in some sort of a domestic dispute. And this court held that he could not be prosecuted for possession with intent to use unlawfully because of that license.
So let me ask you the same question I've been asking everybody else. Do you know of any prosecutions under 415?
No, as my colleague stated, licensing violations seem much more naturally to result in
Revocation.
Exactly.
Yep.
A couple of other things that I will say about standing there. According to defendant, he would have been able to get a license under all valid criteria. I would just point out that on the night in question, before he was even arrested, he was carrying in his car a large capacity magazine that exceeded New York limits on ammunition capacity. He also had the gun loaded in his trunk, which was a violation, according to his own testimony, of best safety practices. It was also a violation of applicable legal restrictions at the time. So one of the inquiries that would have been relevant under the good moral character criterion would be firearm safety, and there is at least some evidence that suggests that there would be questions there. And the idea that this would be any kind of a simple or limited remand or remittal is, I submit, not credible. If I can finally just say one last thing, the reason preservation is important, in addition to all of the things that counsel have said before me, is it is also a measure of the separation of powers. This court has recognized that striking down a duly enacted piece of legislation is not something that should occur in the vacuum, should occur in a vacuum. It should occur only when there has been full and adequate development of the issue, or at least an opportunity for that in the lower courts. And that is to hold otherwise in this case, in any of these cases, would be to significantly expand the jurisdiction of this court, and I submit that is not something the court should do lightly. Thank you. Thank you.
That is something this court has already done in Baker and in Patterson. And Baker was not a mode of proceedings error at all, and yet this court held that preservation was excused because the argument was futile given then existing state practice. That is the rule that controls this case. The government attorneys before this court today although they haven't been saying it, what they're really arguing is that somehow, some way, this court has sub silentio overruled Baker and Patterson. This court, however, has never overruled those cases. All the government can cite to are cases where perhaps futility could have possibly been in play, perhaps it wasn't, but the decisions say absolutely nothing about futility. That is not a good way to read this court's cases. If this court adopts a futility exception, the way to understand this court's law is to say, is that law on the books and has it been overruled? Not to parse records and briefs filed in other cases to see whether possibly this court silently overruled its own precedent.
But is that really a fair argument? Because given Heller and McDonald, it's a different type of clairvoyance that you would need to say, you know what, the Supreme Court is saying I can have a firearm in my home for self-defense. It's not such a huge leap. It's not a Patterson leap to say now, you know what, I think I could carry this gun outside without a license, or I can arm myself and I can take it outside the house. So I hear what you're saying, but I don't think it's as dramatic as that.
Well, but the argument that was futile was the proper cause challenge. So putting aside the fact, and I know that use has been discussed a lot, putting aside the fact that use adopted intermediate scrutiny, which I think everyone agrees would have rendered such an argument futile, but putting that aside, the First Department had an iron wall of authority upholding the proper cause licensing standard and the rest of the licensing standards. So any attorney at least in the New York City courts where Mr. Garcia was convicted, would have been completely spinning his or her wheels having made such an objection. And there's no good reason to incentivize those objections.
Then wouldn't the proper opportunity have been at the appellate division because it's their rule? It's their interpretation of the law.
An attorney could ask the appellate division to overrule itself, but the state's...
Just like it could ask us to overrule a
Right.
prior precedent of the court.
But I think the futility, the analysis as to failure to raise it in the appellate division, that's covered by 473.5 of the CPL, which specifically says that one can raise an argument in this court that has not been raised below. What we're talking about here is whether to excuse the failure to raise it in the trial level. And I don't think that it is a good use of the taxpayers' money and of the system's resources to be telling largely public defense offices to send memos around to every attorney working for them that they should start peppering trial courts with futile arguments because perhaps someday the law may change. I think the better rule is the rule from Baker and Patterson. And that is also a rule that doesn't choke off a constitutional appellate claim forever and deprive someone of the relief that the courts have now said is available to them.
Thank you.
Thank you.